We see the headlines about massive lawsuits and market monopolies, but we rarely see the actual mechanics of how they're being fought. This is EconWorks. We look past the talking points to find where law, economics, and markets actually collide. Let's get into it.
Market consolidation across the Texas healthcare sector has bypassed the overnight mega merger in favor of a much slower accumulation of power. It operates through a strategy known as a private equity rollup. Instead of acquiring one massive competitor, an investment firm buys dozens of smaller independent medical practices over the course of many years, slowly assembling a dominant market position piece by piece. In 2023, the Federal Trade Commission filed a lawsuit against U.S. Anesthesia Partners, positioning the provider as the primary example of this strategy in action. According to the complaint, the company spent a decade acquiring anesthesia practices to gain leverage over commercial insurers. They would negotiate high reimbursement rates and then apply those rates across their entire network of newly acquired clinics, a tactic internal emails described as peanut butter spreading. This method of consolidation is designed to be quiet, often keeping individual acquisitions below the financial thresholds that would normally trigger an automatic government review. Historically, antitrust regulators evaluate mergers one transaction at a time. They look at a single proposed deal and ask if that specific handshake will immediately reduce competition in the market. In this case, the FTC attempted a different approach. They asked the court to treat a decade of separate small-scale acquisitions as a single, unified anti-competitive strategy. This legal pivot relied on Section 7 of the Clayton Act, effectively turning the Texas anesthesia market into a massive test balloon for future enforcement. If the government could prove this theory in court, it would provide a new framework for challenging the cumulative impact of rollups that previously escaped regulatory attention. Before a court can decide if a company has too much power, the two sides have to agree on where the borders of the market actually lie. This graphic shows how the government defined those borders. They looked exclusively at hospital-based anesthesia for commercially insured patients in specific cities like Houston. Using these narrow criteria, the FTC calculated that the defendant controlled a staggering 70% of the market share. The defense argued these numbers came from a gerrymandered map. They claimed the FTC artificially inflated market share by excluding ambulatory surgery centers. Furthermore, because patients don't choose their anesthesiologists, providers actually compete for hospital contracts, a nuance the government misunderstood. Determining whether a monopoly exists often comes down to who is permitted to draw the boundaries of the map. Even if the court accepted the government's market definitions, the lawsuit faced a structural problem. Fixing the market might be mathematically impossible. This diagram illustrates the dilemma. The defendant's first major acquisition gave them a 50% share in Houston. Subsequent deals pushed that to 70%. If a judge forced the divestiture of later acquisitions, the remaining entity would still control half the market. The government's theory of harm was disconnected from any practical remedy that could actually restore a competitive environment. The legal battle ended in April 2026, when the two sides quietly settled on confidential terms just before the trial was set to begin. Because the case never reached a verdict, courts were unable to establish a definitive precedent on the legality of these cumulative acquisitions. This case highlights the physical reality of a consolidated market. Once independent firms dissolve and contracts are unified, corporate relationships are permanently fused together. Blocking a single merger beforehand is a standard regulatory task, but unscrambling a deeply integrated company years after the fact is much harder. Regulators have shown they can identify monopolies that grow in slow motion, but the question remains whether the law has the capacity to successfully restore competition once those markets are already integrated.
Thanks for watching. For the deep dive economic analysis behind these stories, join us at econworks.com. Subscribe to stay informed on where law and economics meet the market. We'll see you in the next episode.